Another set of question is how important is the license IP to the company? If the license IP is only just affects a minor fraction of the product, then the licensee can negotiate hard to lower the cost of the IP. However, if it covers the core functionality or the core value of the product, then the negotiating position is reversed, and the licensee would be in a weaker position. Another question to ask is whether or not the patent provides an actual monopoly or blocking position. Is it bundled with other patents? How does that affect the deal structure, the royalty stacking, and the combination of the patents? How does it affect that? Does it provide freedom to operate? And is this patent a necessary to have or a nice to have? Similar to the questions found by most startups. Is our product absolutely necessary or is it a nice to have? And another factor in there is the geographic scope of the IP. Is it global? Is it United States? Or is it a particular state? Next, we talk about the grant of rights. So the grant of a license, you need to consider whether or not it's exclusive or non-exclusive. What are the license assets? Are they patents only or patent applications? Are there others such as copyrights, trademarks, know-how, trade secrets, tangible materials, software, data, etc.? Also, you need to consider the field of use. The field of use is actually separate than the territory. So the field of use, you can partition the invention to specific applications, such as only for heart treatments and only for diabetic treatment. And so by parceling out the field of use, the patent owner can extract more value. Similarly, in the territory, the patent holder can designate whether or not it's country specific or global or least developed countries. Last but not least, the license agreement should discuss the retained rights to the patent owner. The grant of right can also contemplate how to handle improvement in the technology. So let's say if the same inventor has made additional improvement, does that improvement accrue back to the patent holder or is it a shared project? And also, how long is the rights to the improvement accrued back to the patent holder? The grant of rights should also talk about sub-licensing issues. And of course, the issues are whether or not the licensee is permitted to do this and whether or not they need to notify the owner of sub-licenses. Are there limits on the number of licenses, sub-licenses? What about territory and field? And also sub-licensing fees that are provided back to the patent holder. Those are the key considerations for licensing a particular technology. We hope that this discussion is helpful, and if you have any additional questions, feel free to reach out to us at patentpc.com. We look forward to hearing from you. Thank you.